Пане Тарасе, вітаємо вас на
Taras,
другому етапі
welcome
конкурсного
at stage
відбору
2 of the selection for HQCJ.
суддів на етапі
This is
співбесіди.
the interview
Співбесіду з
stage.
вами конкурсна
Your
комісія
interview will
проводить
be
в повному
conducted by
складі.
all members of our selection commission. That is Steven Markman, me, Ivan Mishchenko, Evgen Mezentsev, Sergei Verlanov, Robert Bergheisen, and Ted Zazhechny. The rapporteurs for your interview are Steven Markman and Evgen
Пане Тарасе,
Mezentsev.
якщо наша співбесіда
Should
буде
for any
перервана, ми її
reasons your interview
продовжимо
be
в інший день та
interrupted,
інший
we
час,
will
про що
resume
ми
it on a different
обов'язково
day
з
and
вами
at a different time.
Під час співбесіди члени комісії
During
будуть
the
ставити вам
interview,
запитання,
our
прохання
commissioners will be
відповідати
asking you questions, and we are
коротко і
kindly
лаконічно.
asking you
Член
to be
комісії, який
precise
задає вам
when giving
запитання,
your
має право
answers. A
обмежити
commissioner
вас у
asking you a
тривалості
question
відповіді.
has the right to
Перед
limit the
початком
time of your
інтерв'ю у вас
answer.
буде можливість
Before
провести
we start
коротку
with the
самопрезентацію
questions,
та
we will
повідомити
give you the
комісію
platform
про
for a
свою
short
мотивацію
introduction
і
to tell us
ті
a
ідеї,
little
які
bit
у вас
more
є
about your
стосовно
motivation and the
роботи
ideas that you
ВККС
have with
та
regards to the
судової
work of
системи, можливо, в цілому.
HQCJ and the
На цьому
judiciary
передаю
in
слово своїм
general.
колегам.
With this,
Стівен,
I'm
Євген,
passing
будь
the
ласка.
floor to my colleagues. Steven, Evgen, you're welcome. So, Steven told me that I will be doing the introduction for you, so I will be introducing you for my colleagues and for our audience. So our candidate, his name is Taras Rym. He was born in 1982. He is a judge of the Commercial Court of Lviv region. He's been a judge there for more than 12 years. The general work experience is 21 years. Experience of working in the field of law is 18 years. You have PhD in law. You presented your thesis in 2011, and in 2021 you got your doctoral degree. You are a trainee of the National School of Judges. You have a high level of English proficiency. You have recommendation letters from the president of the Commercial Court of Lviv region, that is your actual supervisor. You got one more reference from the head of analytical department, and also Mr. Onishchenko, Onishchuk, the head of the National School of Judges, also provided a reference letter for you. Your income in the previous year accounted to more than 3 million hryvnias, and over the past 24 years, the official income of Mr. Taras Rym accounted to almost 8 million hryvnias. In general, the property status does not cause any concerns from NABU. Our candidate has some sufficient assets, and we will be discussing them in the course of our interview. There were 2 complaints filed with HCJ with regards to Mr. Rym, and on all the 3 complaints, no proceedings were initiated or they were returned back to the Finland. And twice, Mr. Rym was a delegate to the Congress of Judges, which shows us that he enjoys authority among his colleagues, and he has proven his proficiency in the Ukrainian language, which is confirmed by the certificate issued on the 4th of August of 2022. With that, I'm passing the floor to you, Mr. Rym. You can add some information in your introductory remarks and tell us about your motivation. Welcome, dear commissioners. Thank you for this introduction. My name is Taras Rym. The name sounds similar to the capital of Italy, Rome, and it's my first time participating in a selection of such a high level. Throughout my entire professional career, I've been working in the field of law, and in particular in the judiciary, because right after graduation from the Ivan Franko National University of Lviv, I started working at the Commercial Court. In the year 2010, I was appointed a judge of the Commercial Court by the decree of the President of Ukraine, and in 2017, I got a lifelong tenure at the same court. On a daily basis, I work with different cases I believe that in addition to our everyday routine, we must constantly improve our professional level, our competence. And that's what I'm doing on a day-to-day basis. After being appointed as a judge, I also entered a postgraduate program at our university, and a result presented my PhD thesis. I was a participant of many international programs. In 2011, I participated in Administration of Justice MATRA program initiated by the Ministry of Foreign Affairs of the Netherlands in 2015. In the early 2015, my mandate expired, and I realized that I would not be appointed back very quickly, so I decided to fill in that time with as much activity as possible. So I intensified my work on the doctoral thesis, which, as was already mentioned, I presented in 2021. Then I became actively involved in the activities of the National School of Judges, and in the focus of my interest was the implementation of the practice of the European Courts for Human Rights as the most relevant topic, as something that must be studied really carefully. I was one of those trainers who was involved in practical assignments, in writing tests within the National School of Judges. In 2016, I participated in the program of the American School of Law, that was Chicago Kent School of Law program, where we had a chance to get acquainted with the American system of law. And in 2018, I completed training within the Ukrainian Helsinki Human Rights Group dedicated to studying the practice of the European Court for Human Rights. I can tell you honestly that I decided to apply for this selection after the beginning of the full-scale war. The war has exacerbated feelings within the society. The war made many people to assume more responsibilities and try and accumulate their knowledge, experience, and skills. That is why I decided to offer my knowledge and experience for the service of my country. And should you decide so, I will be given this office. The trust in the judiciary forms on the level of filing a complaint or a lawsuit. When a person enters the courtroom, that's on the one hand. On the other hand, if you understand that maybe your experience and skills are going to be useful on a potentially higher level, then you need to test yourself out. That's one of the first reasons why I applied. Your selection commission has declared a positive approach towards the applicants, which was, again, one of the arguments why I applied. And the final thing I'd like to say is that the position of an HQCJ member, in my opinion, should not be the end goal. It should be an instrument or a mechanism for a person to be useful in achieving the goals that the society has. And this is everything I wanted to say. Thank you.
Thank you, Taras, and let's start with your motivation, because there is a restriction in terms of the number of words for the motivation letter, but you made quite a powerful statement saying that you would like to apply the principle of irreversibility of punishment for purposeful illegal actions of judges. how am I going to intend to do this? How am I going to intend to establish these principles? Through what measures? Through what forms? Well, I was not talking just about punishment, but about protection as well. And if we speak about protection, I cannot invent any new things. There are some actions taken by a judge and within his position, and if they do not correspond to the law, these are called purposeful actions, and there must be punishment for that, be it disciplining. And we have a long list of punishment that may come, be it administrative or criminal punishment. That's what I meant by inevitability of punishment. You made an issue. You actually issued the power of attorney, or actually no, vice versa. There was a power of attorney from your parents to dispose of the money and some property. What was the aim for this power of attorney you got from your parents? Well, that was in March 2022. We all remember what kind of events were happening at that period of time. These events are still going on, unfortunately. And in the conditions of such uncertainty, my parents decided to issue such power as attorney to me, to my brother, and to my wife. This was the power of attorney giving the right to dispose of their property. Another property issue. On the 13th of May 2011, your wife, Olena, got ownership of the land in 2010. In the declaration, the area of this land plot is 0.423, but according to some other data, well, this is the real data, and in the declaration, the indication is that this is 122 square meters. So could you explain the difference, and was it through privatization or was it on some other grounds that your wife got ownership of the land plot? Well, the answer is rather simple. It was within this privatization procedure that land plot was allocated by Lviv City Council within the privatization procedure to service, to maintain the residential building. Yes, that was the building she owned. Clear. And what about the difference in the square meters? So what is is it 423? It's 422 square meters. Okay. What about your vision of criminal responsibility for illegitimate, illegal decisions? Is that generally exist in Ukrainian criminal law? And is it not a tool to exert pressure on judges in their judicial activity? Well, over the period of my work, starting with 2004, my work in court, I didn't hear about any cases when this norm of criminal law was used as a means of exerting pressure on the judge. The problem of this norm is about the fact how we determine the purposefulness of illegal actions. Purposefulness of the illegitimacy of those decisions. What I mean is that it is a problem to prove that the judge really intended to violate the law, not to obey the law, and to pass the decision which ran counter to the law. Absolutely did not correspond to the norms of the law. So I don't see any special reasons for concern here. We should not consider this to be a tool of exerting pressure on judges. Thank you, Taras, and let me pass the floor to Stephen. Stephen, you're welcome.
Thank you. Thank you, Mr. Taras, for your participation in this competition. My colleague, Judge Mezentsev, has asked a question stemming from your assertions in question 8 of the motivation. Let me ask you about another one of those assertions, please. You indicate in Section 8 that you will afford effective protection of judges from groundless complaints and unlawful attempts to influence. What exactly do you hope to do in order to achieve those?
Well, I think that one of the reasons of distrust, societal public distrust in courts, is not just that judges sometimes show some conduct that shouldn't be there, but quite often we have cases when the problems of the judiciary are used by other state institutions, including politicians, political authorities. We know some cases when just a second. We know some cases when we get the impression that state authorities are using the judicial issues just to distract attention from their mistakes. Law enforcement bodies sometimes disclose some materials of pre-trial investigations, and these materials are not necessarily that much related to the possible crime. And there have been numerous cases when officials commented upon the case which has not yet been investigated and which has not yet been transferred to court. And quite often we have seen the examples when the High Council of Justice was addressed with some concerns, with some claims by politicians, and they had claims against the judge. And it seems to me that in such cases, the High Council of Justice can actually have the same approach. And, for example, it should consider these claims only with the obligatory participation of the claimants. It seems to me that in many cases, in most cases, when this claimant appears at the meeting of the High Council of Justice, he will not have a lot to say because he's not generally aware of the very essence of the claim. That's what I meant.
So this is not designed principally to refer to complaints or criticisms of the judiciary from citizens or newspapers or civil society organizations. Is that a correct understanding?
Yes, I don't mean these things here. Every citizen has the right to file a claim.
Okay. Let me ask you, Judge Rym, by your actions and not by your words, what have you done to give us confidence that if we place you on the HQJC, you would commit yourself actively and strongly in favor of judicial reform? Pretty simple question, I think.
Stephen, it's not a simple question, I would say. As far as I'm concerned, it's not simple because court traditions, judicial traditions in Ukraine, or the traditions of justice administration, which are not related to a direct hearing of cases, have never presupposed activity of judges in public space. That's why it's a sudden challenge, at least for me, to go public, to be scrutinized under some microscope by the public, and to have public speeches in different forms of a high level. And this is accounted for by the fact that your words can be distorted. Some of your ideas can be manipulated. That's why I just would like to explain why, for me, this question is rather difficult. I am the proponent of the judicial reform because with my actions, I show that I'm not just staying in one and the same place. I try to ensure self-development, and I take active actions. Sometimes, you have to stand a little bit aside to have a look at your activity from the position of an alien observer and to analyze what can be improved in your own activity. That's why it seems to me that this striving of mine for self-perfection, self-improvement, and self-development could actually show you that I support the changes that we are declaring and that I will work at those changes.
I don't mean to be difficult, but we all understand that there are differences of opinion within the Ukraine judiciary, and there's been some considerable resistance among some parts of the Ukraine judiciary to judicial reforms. Not just the present reform, but over the years to a series of reforms. And if this commission is committed to the idea of a high qualification commission which will carry out significant reforms of the Ukrainian judiciary, how are we to know which judges will facilitate those changes and which judges, once they're placed upon the commission, will not do the same? There must be some means by which we can distinguish between those classes of judges, aren't there?
I think that the selection commission is actually showing the example how to do this. You can do it through collection of information. The information is supplied to the commission from different sources, both official and some informal sources and channels. The next stage is scrupulous study of this information. And one of the most important stages is the interview stage, because it is at the interview you take into account the indicators which you have reflected in your methodology. And of course, the same indicators will be applicable in the work of the HQCJ. So following those indicators, you check whether the person complies with these indicators and criteria at the interview stage. How do you check this? Well, different tools and techniques could be applied in this respect. First of all, this is problem setting. I mean, you can ask one and the same question, rephrasing it, or you can ask the same question in half an hour, and you double-check this. Sometimes there are questions that are referring to the so-called overlapping or cross-referencing indicators, like one answer to one question can give rise to another follow-up question. And in that way, you can actually analyze and get the overall picture about a certain candidate, and you can see whether this candidate has those indicators, integrity and professional competence indicators in place or not. So it seems to me that it is using those techniques that one can actually determine what the right candidate is.
So you think a question like the one that I addressed to you, asking about actions that indicated some receptiveness or support for judicial reform, is either a clumsily expressed question or it fails to reflect the realities of the Ukrainian judiciary and the constraints upon the judiciary? Can you give me any counsel as far as a better question to ask? Again, I'm not trying to play games with you. I'm just trying to understand whether you have the commitment to judicial reform that at least I believe is a indispensable condition to being precondition to being placed upon the High Qualifications Commission. I think that's the mission of our selection commission.
No, I didn't mean, Stephen, that question is clumsy and that you are just asking questions for the sake of asking questions. It just seems to me that the fact that you're asking similar questions at a different point of time during the interview, this helps the candidate to better clarify what it means, and it helps the commissioners to better understand and kind of double-check what the candidate is saying, whether he is sincere and honest in his answers. That's what I meant. As far as my dedication to the judicial reform is concerned, I could actually continue with my answer, and I would like to say here that, for example, in the judicial questionnaire, every judge at some point of time was supposed to give the list of 10 decisions that would prove professional competence of this judge. That was the suggestion of the HQCJ. And once I started thinking what decisions I should have provided on that list, and I provided decisions from the initial point of my career and up till the very date of qualification assessment. And if you embrace the whole period of your work, the commission may analyze whether anything changed in that judge over the period of his work. It allows the commission to see whether the candidate is somehow growing and developing and improving the structure of his decision, whether he is really trying not to stop at one place, and whether he is really developing. So I think that a certain conclusion could be made on the basis of that. But if we speak about some specific things I did which prove that I'm committed to the reform, I don't think that I can tell you any specific things.
Okay, thank you, Judge. I appreciate it. Let me move you on to my colleague, Judge Zarzeczny.
Judge Rym, I took some interest in your report to us, both in the materials that have been provided to us, together with your opening remarks, concerning your role and involvement at the National School of Judges. And you described that as being a teacher, a developer of curriculum and training. You've also told us in your introductory comments that you were actually involved in drafting some of the practical assignment of the HQC, or for the HQCJ, as well as the examination questions. So I take you to be very familiar with the interaction between the National School of Judges and the High Qualification Commission for Judges of Ukraine. We have had some candidates express the opinion that because of the huge volume of work that is going to be facing the new members of the HQCJ, that one of the solutions would be to shorten the period of study of judge candidates at the National School of Judges, and perhaps shorten some of the other procedures of the HQCJ, the former HQCJ. So let me deal with the first aspect of this. What is your opinion with respect to whether or not any significant or major changes should be made to the 8 or 9 month process of education of judge candidates, new judge candidates, and whether or not there are any changes that you would like to see made to the curriculum?
I think that the period of studies is quite justified, because this timeline, this period, takes into account the legislative procedures that are enshrined in the law. If you ask me, I would probably suggest changing the procedure of selection of judges if these are the candidates that are appointed to the judicial position for the first time. Now we have the following procedure. All candidates submit their applications for being appointed a judge of the court of trial instance, regardless of their specialization. But if we differentiate between specializations and every candidate submits the application for a certain specialization, this would actually accelerate certain procedures, because the candidates who want to go to the administrative court only or to the commercial court only would hardly need a training, additional training in criminal law or criminal proceedings. That's why, in this respect, I suggest that this change should take place. And in this respect, the timeline of training could be changed, but only in this respect. Otherwise, it's well-grounded, the timeline. What else would I change and what would I add? Well, one of the problems in the judiciary, which has been mentioned quite a time, one of the problems in the judiciary and in the previous composition of the HQCJ, the problem it had to settle is the reasoning and motivation of decisions. The National School of Judges of Ukraine has developed a training on this, but this is just a one-day training on the reasoning of your decisions. I think that much more time should be dedicated to this aspect of the judicial work. If I'm not mistaken, after judges were appointed to the Supreme Court in 2017, they were also offered a kind of guidance training, and a lot of attention there was paid to reasoning on motivation of court decisions. It seems to me that a lot of us, me and my colleagues, would have a lot to work at in this respect. Thank you.
Yes, thank you for your answer and your insights. You point out, in response to the criteria for applicants to the HQCJ, and in particular, integrity, the integrity criteria, among other things, the following. I consider the following examples that can confirm my integrity. Promoting the professional growth of my wife through parity distribution of family responsibilities and active participation in our son's upbringing. Now, I have a couple of questions for you. What is your wife's career? And then I'll ask you the second question.
Well, my wife is also a lawyer. She is doctor of law, and she works at the Ivan Franko National University of Lviv at the Faculty of Law at the Department of Social Law. She is also a very active person involved in different projects of the Council of Europe in particular, and it seems to me the OSCE projects.
Now, that observation on your part suggests to me that you have quite a progressive view respecting gender equality and perhaps not stereotyping the role of women, for example, in a marital context. I'd be interested in hearing your views with respect to how gender and what role gender equality can play in the work of the HQCJ.
As far as I understand, I hope you understand, I understand your question, gender equality is important from the following point of view. It should enable us to provide women with equal opportunities for participation in their own development, for ensuring their own development. And they also have the right to give their experience and their professional knowledge to in the process of trying to attain the goals they set for themselves. I'm not an expert in gender equality in the context of the study of this problem. I mean, I don't study this issue, but from what I know, I think that if we speak, for example, about quotas, well, maybe it would be a justified step, but it seems to me that it is just a forced step. It seems to me that a woman who can achieve something wants to get the result not because of quota, but because of her professional achievements, because of the fact that her professional competence is high, and because her experience is demanded, is something that is needed by someone. It seems to me that the quota of women in state institutions, some executive authorities or some supervisory bodies is just the result of the policy of the state and that is the policy of the past. I mean, if women reach some heights, so to say, if they become MPs, if they become members of some executive authorities, that is not because of their gender, that's because their professional competence and not quotas.
Yes, and you also say a little farther on, and I would like you to explain this. The owner of our family's property is only my wife. Now, why is that? What is the logic or what are the reasons behind that situation?
Well, this is the circumstance that may actually cause some concerns of an alien observer. When I graduated from the university, and before I became a judge, I owned some assets, I had some corporate rights, I was the owner of some real estate, and as you can see, the major income of our family, besides my remuneration, is leasing this property. When I was undergoing the appointment procedures for the High Council of Justice in 2009, there were a lot of questions raised to me as to whether I can really lease real property, real estate, if I'm a civil servant. I was trying to convince everyone and the members of the High Council of Justice that I was entitled to do this. They still objected to that, and they thought that I, as a civil servant, could not have any corporate rights. I was not a member of any executive body of any legal entity at that time, but still they claimed that I could not have those corporate rights. So I had to get rid of this real estate in favor of my wife. And since then, I have never had my own property.
I see. Thank you. I'm going to turn your questioning now to my colleague, Mr. Broekhuizen. I expect he has some questions for you as well.
Thank you, Mr. Zazetsny. Yes, of course, Mr. Rym, I have some questions for you. Good afternoon. The first question I have for you is that when I read your motivation letter, you say that you're familiar with the process of permanent reform of the judicial system, and that allows you to understand that the obstacles to be removed. And if I then read your motivation letter, it refers to all kinds of ideas to remove those obstacles. But the letter does not address what is the real reason of the reform, why the reform is necessary, and why there should be obstacles to be removed. and also not why there is the need for a permanent reform. And being a lawyer from a European country, I don't know that either, but what I do know is that I read, let's say, quite a lot of publications by the EU and our media, and that alleges that there are quite some issues in the judiciary in Ukraine. And they not only have to do with the lack of judges, but also with integrity issues. And you do not address that in your motivation letter. Maybe you can respond to that, why that is so. Because if you want to be member of the HQCJ, of course, something needs to be achieved. And then we need to be clear that we are all looking for achievement of the same thing.
Well, to answer this question, I would start with the following. And what do I want? What do I want to achieve with this position, and what is going to be the outcome and the result of this term of mine in the position of the member of the HQCJ, if I'm elected? I cannot be that optimistic and claim that when the term of the new HQCJ is over, we will definitely see incredible results and outcomes. It seems to me that the main task for the new High Qualification Commission of Judges of Ukraine, the main task of it is going to be laying down a very solid foundation on which the institutional system will be built, on the basis of which the judiciary will be developing. And further compositions of the HQCJ will just have to develop it further on. What are the principles we ground our activity on? These are the principles and the statements which are determined by the law and which are determined by common sense, in fact. What is integrity? Independence, honesty, lack of prejudice, impeccable behavior, nepotism, improperty issues, and things like that. There must be only those candidates, only those lawyers allowed to work in the judiciary who are professionals of the highest level and who are also absolutely people of integrity. I'm not sure whether I've really answered your question, but that's how I understood your question, at least.
Okay, when I listen to you, you're not really optimistic, and my comment would be that the members of the HQCJ better get optimistic, because there needs to be lots of change. And I'm quite sure that the EU will not allow Ukraine to enter into the EU, even when not large steps are made. And the first thing that should happen when those steps are to be made is, of course, that the members of the HQCJ themselves are people who are beyond any questions of integrity. And do I understand correctly that you believe that you are such a person? And why?
Yes, I consider myself to be a person like this, a man of integrity, and I can really work there in the HQCJ. Over the period of my conscious life and professional career, I've been trying to show this with my example. And you can see it in my declarations that I always declared the income and the assets which our family had.
Well,
in lease agreements, there is you have them in your materials, you will see that these are absolutely realistic amounts, and all taxes were paid from those amounts. And seems to me that in the conditions when we had the 90s and the 2000s, and a major part of the Ukrainian economy was shadow economy. So in this background, my actions can really show you that I'm a man of integrity.
Okay. Well, in the information, did you look at the information that's available about you?
Well, as of yesterday and today's morning, I saw the information from the Chesno movement. I haven't seen any other information.
Okay. Well, the information shows that your family is quite well-to-do. And yeah, I cannot read everything that's in the file because it's in Ukrainian and I don't read Ukrainian. And the only thing I can look at is, let's say, the translations and the analyses that have been made for me by our staff. And I read here, for instance, that the declarations show that your wife has cash in US dollars. And then it says, however, it is stated that she, as a family member of the declarant, failed to provide information about the amount. And that means that her assets in dollars are not mentioned in your declaration. And there may be a reason for that or not. The point is, of course, that if and when you would be elected as a member of the HQCJ, you would need to ask from other people to fill in complete and full declarations, and which means anything manking on your own declarations would then be, let's say, an allowance for other people who come to you to do the same, which, of course, is not acceptable. So what you think about this is, why didn't you put in your declaration the amount of cash in dollars that's owned by your wife?
The point is that I think that there is no mistake here. First of all, the declarations of judges are subject to comprehensive inspection, comprehensive check, and the law allows for cases when members of the family do not provide some information, and these situations are not considered to be a violation. Here is another thing. The declaration of income is in open access, and my wife has not provided information only on one aspect, only on one item, the amount of cash in US dollars. All the other information about her income and her property is there. She has provided all the other information. And this allows to actually analyze rather scrupulously the situation and to understand whether our income and our way of life corresponds to what has been declared. And the main reason why she does not provide me with this information is just security issues.
Well, but if I'm critical about your answer, I would say there is so much declared that the cash amount in dollars could be declared as well. And how can you fight effectively corruption even when the people who are a member of the HQCJ are not declaring their full value also of the dollars they have in cash in their hand in the declaration, which means that there is a hole in the system, and the hole in the system makes that other people also can have the hole in the system, which means that there is no total certainty that the declarations are correct. And that makes, of course, the system leak. Wouldn't you agree?
I think that we do have the requirements of the law in place, and I do fulfill these requirements of the law. I think that there are very many people in Ukraine who similarly think, who have the same idea as I have. Well, I don't know what the law, if the lawmaker, the legislator thinks that this needs to be corrected, then probably the amendments will be introduced in the law and it will become binding to declare absolutely everything. And then the people who do not declare some items and who have a problem I have will not be allowed to hold top-level positions.
So that means that if you're a member of the HQCJ, you would be elected, that you wouldn't see any difficulty in that people who would solicit for a job in the Ukrainian judiciary would not declare their cash in hand.
Well, I think it will be guided by the whole integrity of information items which I collect about a certain candidate.
Yeah, but the point is that in order to select someone, you need to have the full picture of all the information that is available. If there's a leak, you cannot make a selection, can you?
It seems to me that generally there are no perfect people and no perfect situations, and that's not only about Ukraine. And it seems to me that a certain leakage or a certain gap in itself does not yet prove and does not yet give the grounds for any radical or unambiguous decisions and judgments. And that's why I follow this principle, and probably you will agree with me that it is systemic study of all the information collected about a candidate that can give you this full picture and can actually give you grounds for some unambiguous judgment.
Thank you, Judge. I will pass the floor to my dear colleague Sergey.
Дякую, пане Гурт. Доброго дня, пане Тарасе.
Good afternoon, Taras.
У мене буде запитання до вас.
I will have a question to you concerning your judicial activity.
З вашого суддівського досьє
We can see it from your judicial dossier that in June 2018 you addressed the High Council of Justice with the information, with a statement that there had been interference into your activity because law enforcement bodies seized the materials in the case, the investigation, the proceedings in which had not been over. But the High Council of Justice did not find the grounds to respond. Could you comment upon the circumstances? Well, it's really true. I had a case which was a rather high profile, a rather important case, I would say. And during the case consideration, the issue arose about forensic examination of documents. And since these documents were rather old, it was year 1998 or something, and the documents were available only in one copy. And the other party was trying to appoint this forensic examination to check when the documents were produced. When this happens, during this examination, the document may be destroyed. So on the basis of this examination, there could arise a situation when the only original document could be destroyed. And that's why when we clarified all this, and when the investigator from law enforcement bodies came to seize the document, of course, this evoked a major concern of mine, and I objected to that because, but still there was the legal resolution of a judge about seizure of those documents. So I was concerned what to do with this case next. And I took into account the resolution of the plenum of the Supreme Court of Ukraine, which said that in such case, this may be regarded as interference into the independence of judges. And there were also some decisions of the Council of Judges of Ukraine, and it was under those decisions that it was recommended in case original documents are seized within some cases, within some proceedings. So it was the recommendation to inform High Council of Justice of that. And I would like to stress that in this situation, I didn't have the grounds to claim that there was definitely interference in my activity, but the situation was so confusing and so unclear that I still decided to use this opportunity to use those recommendations and to inform the High Council of Justice. Okay, clear. Thank you.
Дякую, пане Тарасе. І
Thank you,
наступне
Taras. And
запитання
here
до
is the
вас.
next question.
Чи проходили ви кваліфікаційне
Have you
оцінювання?
passed qualification assessment with the High Qualification Commission of Judges? Yes.
Скажіть, будь ласка, як ви вважаєте, чи
What is your opinion concerning the following? Should the procedure of judicial assessment be improved or not, and why? Well, I think yes. This procedure can be improved. And again, I'm not going to tell probably some new things, but maybe I can just comment on this. The major issue is about the methodology of assessment criteria. I had a look once again at this methodology that was approved by the High Qualification Commission of Judges of Ukraine, and it includes three basic criteria. The first is the criteria of competence, the second one is the criteria of professional ethics, and the third criteria is the criteria of integrity. For each of the criteria, you may get a certain number of points, some score, and there are also some sub-criteria, and for each of those sub-criteria, you can also get some points. I was frustrated because advanced training is the criterion according to which you can get only 10 points. I mean, by advanced training, your publications, your scientific activity, it's not considered to be an advantage for a judge. So how do we encourage judges to participate in the trainings of the National School of Judges then, if it is only 10 points out of 1,000? There are also criteria of individual competence and social competence, and you may get 100 for each of them. But if we have a look at the factors that enable us to assess these criteria, we will see that they are the same. This is testing of moral and psychological and general skills, both of the criteria, so they overlap. I don't know. Probably we still have to study this because I'm probably not an expert in the testing of moral and psychological qualities, but as an alien observer and as a person who participated in the qualification assessment, I still have some frustration about this. And two more criteria, like professional ethics and integrity, are the criteria which have some items within them, like other indicators, and you may get 150 points for those other indicators. So it's not clear. So we can see that on the one hand, probably the High Qualification Commission of Judges was trying to leave some room for discretion, but on the other hand, this led to the situation when a lot of people were not clear about where the points were coming from.
Добре, дякую вам.
Okay, clear. Thank you, Taras. And if you allow me, I would also like to tell a couple of words about the practical assignment.
Ми зрозуміли, ви
Well,
до цього
we are
на
actually
запитання
clear with this
судді
because while
Тедра
answering
відповідали з приводу того, що
Ted's
ви
Zhechny's questions,
вважали
you
за необхідне
said that
покращити,
you would consider it to be
саме щодо
necessary to
мотивації і аргументації
improve
судових
the
рішень. Це ми
reasoning of court decisions, so
Хотілося б
it's about
почути
practical
ще, що ви,
assignments.
хотіли б покращити безпосередньо при оцінюванні суддів.
And we would also like to find out what you would like to improve during the assessment of judges. But okay, let me give the floor to the chairperson. Thank you.
Пане Тарасе, а як з англійською у
Taras,
вас?
what about your command of English?
Can we speak English a bit? Не перекладайте, будь ласка, це я до
So the
перекладачів
request is
звертаюся.
not to translate now, not to interpret now.
Can
They
we
will
have
speak
a
English.
bit of a conversation, right?
Yeah, I think we can.
Um,
But mind, please, that I didn't speak English well.
Well, of course, but you indicated in your bio that you have a high level of English. You say that a high level, And you have a certificate. Yeah, you have a certificate, right? What is integrity? What do you think about integrity? Can you provide us with a meaning or in some kind?
Well, I cannot do that because I cannot say that in Ukrainian. I can say it.
Okay. So you have some level. Okay, thank you. Повернемось до співбесіди,
So
до
let's
співбесіди
get back to the
українською мовою.
Ukrainian part of the interview.
Скажіть, будь ласка,
Could you please tell
була така
us,
справа в Личаківському районі.
there was a case in Lychakivsky District Court long ago about some arbitrary construction development, and the claimants were you and your wife.
Ви можете якби трошки
Can you tell us
контексту
more about the context of this case
з Львівською міською радою?
with Lviv and about this dispute with Lviv City Council? Yes, I can. So, in your materials, you can see that my wife is the owner of a lot of real estate.
Якщо потрібно. Але початково ми набули право.
So initially, we got ownership of the apartment in question. It consisted of two parts, but we got ownership in 2003, 2004. This was a house. And in parallel with the money obtained from the lease of this house, we did reconstruction, and then the question was about registration of the results of this reconstruction. We somehow failed all the time to come to an agreement with certain local self-government bodies, and we took into account the judicial practice, the court practice that was valid back then, and we decided to file a lawsuit in court about acknowledgement of our ownership.
Мене насправді
You know,
цікавить
I'm
саме цей
in fact
момент,
interested
бо,
in this point very much because in the court hearing, the representative of Lviv City Council
виходив з того, що
said that actually the reconstruction was not based on the previous approval coming from Lviv City Council. You didn't have the permission to perform these works. So did you address them before that, or you just started reconstruction and then you wanted to register the results? We got down to reconstruction right away. Okay, clear. In your motivation letter, among the steps or among the measures that will raise the level of trust in the judiciary, you mentioned that there should be lower load of the trial court judges. If trial court judges are listening to us, of course they are applauding to you now, but how do we achieve this reduction of load? Because in fact the load is only increasing. I think that the problem is a systemic one. And to solve it, we would require a lot of organizational and legislative effort. For example, introduction of mediation procedures, exclusion of some cases and disputes of not inherent in courts, not characteristics of courts from their control, from their jurisdiction. I mean that we could take measures for the mediation procedures to start working. It seems to me that they are not yet that much relevant. Well, maybe they are. I will not claim this for certain, but they are not that much relevant because in our society we have a very high level of trust, not just in state authorities, but in each other. So it seems to me that people who start quarreling and having a dispute just do not believe that they can come to an agreement. Another aspect is a violation of the duty to take into account the decisions of the Supreme Court by state authorities in their activity. For example, the pension fund bodies. You may correct me if I'm wrong, but they tell their claim applicants that they will pay the amounts of money due to them only on the basis of decisions, regardless of the fact that under identical conditions, court has already charged the money from them, and that the Supreme Court already provided the explanations as to what needs to be done in this case, and there is a legal opinion on that point. So if these things are implemented, it seems to me that at least partially we will reduce the load of trial court judges.
Зрозуміла ваша позиція.
Okay, clear.
Дякую. Чи будуть
Thank
у
you.
членів комісії ще запитання?
Will the commissioners have any other questions to the candidate? So our interview is about to finish, and
Будь ласка, підсумуйте її.
I wonder if you could sum it up. In my introductory speech, I told you that this is my first selection, all the more of such a high level. I will just express my gratitude to the selection commission, as other candidates did. I will express my gratitude for your attitude, for your principles of asking questions you followed, for the intelligent tolerance which you have shown and which you're showing to all the candidates, with which you are treating all the candidates. I'm sure that all your effort and all our effort will lead to great results, and I do believe that the new High Qualification Commission of Judges of Ukraine will really be the foundation let down I told you about, and it will be on the basis of this foundation that a great institution and a great system will grow. Thank you. Thank you, Taras, and that is the end of our interviews. Thank you for your participation. Good luck, stay safe, and goodbye. Goodbye.